Good morning, everyone. I'm not sure when it happened. There was a time when things in the courts used to start at 9, and then one day they just starting at 8:30, and I feel the same thing about this conference. I always used to start at 9, and this year, 8:30. It has become customary at the outset of an event such as this to read a land acknowledgement to acknowledge the traditional territory that we are on. This year, at the request of our Indigenous Committee, I will not do that. Instead, I would like to acknowledge and recognize many Indigenous members of the Criminal Lawyers Association and indeed our Indigenous Committee. The CLA has 24 committees, all of which are filled with dedicated members who work tirelessly on behalf of our organization. Over the next 12 months, the last year of my presidency, I hope that all of our committees will attempt to properly acknowledge our Indigenous members and ensure that their unique perspectives are properly taken into account. I recognize the necessity to further reconciliation through the support and retention of our Indigenous members. I'm thrilled to be here in person, thrilled to be celebrating our 52nd annual Fall Conference with all of you. I've been fortunate to have attended many fall conferences over the years, and I know that there are countless volunteer hours put into the planning of this event. I want to begin by thanking our conference co-chairs, Michelle Johal and Adam Weisberg, along with the members of the Fall Conference Committee, Stephanie DiGiuseppe, Matthew Gurley, Sweta Cheshpal, and Lauren Wilhelm, for all the time and energy that they've spent putting this event together. I'd also like to do a special welcome to all the attendees from outside of Toronto. We know that this was an extra effort for you this year thanks to the Taylor Swift factor. We've committed to not playing any Taylor Swift music during the conference this year to demonstrate our compassion and understanding. We have a wide range of topics being discussed and presented. They impact all of us in the criminal bar. The expertise of our presenters is invaluable, and I'd like to thank all of our presenters for joining us over the next 2 days. Thank you also to all of our sponsors and our partners. You play a crucial role in making this event possible, and I want to name and recognize all of them individually. Our platinum sponsor is the University of Toronto Press. Our gold sponsors are Accounting for Law, Inc., Greenspan Humphrey Weinstein, Heller Hunter Azevedo, Sandberg Barristers, Ex-Copper Professional Corporation. Our silver sponsors are Chug Law, Clio Cloud-Based Legal Technology, Cosmolex, DeNovo Group, Inc., Emon Publishing, Leva Freeman Dent, LLP, Osgoode Professional Development, Rangefinder, Smith-Litkowski Criminal Trial Appeal Lawyers, Thomson Reuters, and our bronze sponsors are Brendan Neal, Just for Today, Lacey Naster, LLP, and LawyerLocate.ca, Inc. And finally, our transcription sponsor is Transcripts Ontario. I'd like to thank Seneca College Law Clerk Diploma Program for supporting the conference yet again this year by providing our volunteers. Thank you. And a few housekeeping items before we get started. The latest agenda, speaker bios, materials can all be found on the conference hub. All registrants were emailed access information earlier this week. Hopefully you all have it. There's also a QR code on the back of your name badge that will take you to the hub. Please do not share these links. Only those that register in advance can access the hub and claim the CPD. The password, I'm told to remind you, is CLA, all in caps, 51, capital F, fall. So CLA 51 fall. Hopefully that will work. We will continue to update the conference hub if any new materials are going to be provided. All the sessions here are being recorded. Pending the quality of the recordings being double-checked, we will post them by December the 5th on the conference hub. There is an annual general meeting for the CLA today at 5 o'clock. All the members are encouraged to attend. The agenda and several committee reports are posted on the hub. A special celebratory cocktail reception with entertainment follows at 6 p.m. and hopefully everybody will join us, members or non-members, but especially our members. Be sure to visit our exhibitors. Food and beverages will be provided in the exhibitor area. There are 2 live feed rooms. If you don't want to sit here and be quiet, you can go to the auxiliary rooms. They're close by if you want to go there instead of participating in the main ballroom here. And pending time, Q&A will be offered towards the end of each presentation. That's aspirational, if you guys remember past events. There are 2 stationary microphones for in-person attendees to use at the front of the room for asking questions if those opportunities should arise. I'd like to now introduce Matthew Gurley to the stage, who's going to introduce our first panel of the day.
Good morning. Our first panel today is on the new reasonable expectation of privacy in the wake of the Supreme Court's recent decision in the Bytensky case. We have a range of perspectives here to bring to bear on this interesting issue. From my left, first we have Professor François Tanguay Renaud from Osgoode Law School. Professor Tanguay Renaud has been on the faculty there since 2008, teaching in criminal law and procedure, among other areas. He had his law degrees from McGill, was a Rhodes Scholar at Oxford, clerked at the Supreme Court of Canada, and has published widely on criminal and constitutional law. Next to him is Daniel Song, KC. He's counsel to Pringle Law, practicing in both BC and Alberta. He's an adjunct professor at the Allard School of Law at UBC and a fellow of the American College of Trial Lawyers. Finally, to his left is Ira Glasner, who's counsel at the PPSC. He's a member of the Integrated Road Team, which provides legal advice to investigative agencies and prosecutes complex cases across the GTA. He has a particular interest in cyber crime and cryptocurrency and regularly lectures to law enforcement. Please welcome our panel.
Good morning, everyone. Could I have the slides on, please? Yes, no, maybe? I can present without slides if there's an issue. Could you just give me the thumbs up if... That's a really good question. Sorry? It should be the number 1. There's no other deck for this presentation. I'm the academic, so I've worked harder. Okay, I'll start regardless. So thank you for having an academic in your midst. I want to greet everyone Osgoode in the room. So I've been asked to speak to Bytensky and to give a bit of context. I'm the academic here in the room. So as you'll know, Section 8 of the Charter entrenches everyone's right to be secured against unreasonable search and seizure. Now, if you were just to textually read this provision, you might think that whenever the state looks for or non-accidentally gathers information about someone, well, it should do so reasonably, but the Supreme Court has interpreted this provision much more narrowly as exclusively protecting so-called reasonable expectations of privacy. I'm going to refer to them as REPs. So for state action to be regulated under Section 8, it has to invade at least one such expectation. If not, there's just no search, no seizure, and there can be no infringement of Section 8. Now, a few things to note about this is that it was never intended to be such, or at least initially. Justice Dixon and Hunter and Sutton, the seminal case that speaks to Section 8, said that he was wary to foreclose the possibility that Section 8 could also protect other values than privacy. But this caveat has been ignored since. And in fact, the Supreme Court has never really given us any rationale for insisting on this one threshold for the application of Section 8. Right? It's given us a lot of thinking about why reasonable expectations of privacy matter, but it hasn't told us why that's the one threshold that needs to be satisfied for Section 8 to apply. The other thing to note is that so this inquiry in terms of whether someone has a reasonable expectation of privacy is supposed to be normative as opposed to descriptive, the court tells us. So it's an inquiry about what REPs people should be entitled to expect from a constitutional standpoint. The court has outlined a number of factors that one should think about when assessing this question. You have a number on the board, but it's told us that none of these factors is determinative, and in fact that this list is not exhaustive, and it's also emphasized that the existence of a reasonable expectation of privacy should be, so the inquiry should be contextual, fact-based, based on the totality of circumstances. So the guidance from the court that we've received is really woolly. It's really non-directive. And so the analysis actually leaves a lot to judicial discretion. And that's reflected in many decisions. Now, it is a meaningful threshold. If you look at the history of Section 8, there are a bunch of cases where the court found that no reasonable expectations of privacy existed, where you might think that's actually counterintuitive. So the court has told us, for example, that if you say something to somebody else without it being recorded, could be to a police informant, that's not protected by an REP. Now, think about the pedigree of using informants to surveil people. Think of, East Germany during the Cold War, and you might think, well, that's a questionable finding. Think also about Tesling, where the court found that heat emanations from houses, which were captured by infrared cameras, did not import a reasonable expectation of privacy because they did not, what they told us about what went on in the house was not sufficiently revealing. Now, that's also interesting because they tell us at least something that's going on in the house. So these images can be used as part of the information that's used to acquire a warrant, just not enough on its own. But what it tells us is about something that's going on in a house. And the court has told us that there's no place on earth where persons can have a greater expectation of privacy than in their house. So in the US, in the case of Kelo, the Supreme Court decided the case precisely in the reverse, where they found a reasonable expectation of privacy. Or think about McGregor, decided more recently. So in McGregor, the court asserts that, despite the colossal amounts of information that, personal computers contain, and actually the difficulty of just precisely tailoring searches to certain kinds of files without, the plain view doctrine still applies to computer searches. So if the police happen to stumble on evidence of crime while carrying out an otherwise legal search, while privacy interests don't protect people against such seizures. Now let's move on to Bytevets. So in a number of recent cases, which have to do with telecommunications and the internet, tables seem to have turned a little bit, maybe drastically. I think it's even questionable after reading Bytevets, how much work privacy is actually doing as a threshold consideration in the court's analysis. Now, I think this shift can be traced back to Maraca 2017, but let's focus on Bytevets. So at issue in Bytevets was whether people have an REP in the external IP addresses that are associated with their activities on the internet. And that is even insofar as such IP addresses don't, in and of themselves, reveal anything about their identity. Just to be sure, right, in its prior decision in Spencer, the Supreme Court had already held that an internet user as an REP in the subscriber, the identifying information associated with their use of given IP addresses, information which in that case was possessed by the user's internet service provider. So the issue in Bytevets was with the IP addresses themselves, right, devoid of identifying information, and the majority of the court, deeply divided, holds in the end that internet users also have a reasonable expectation of privacy in such bare IP addresses. Now let's start with Cote's dissent, Justice Cote's dissent. She's joined by Justice Wagner, Rowe, and Obonsawin. Her dissent's kind of reminiscent of the traditional approach to REPs. And she actually firmly objects to the approach which she ends up ascribing to the majority, according to which any steps taken in an investigation engage a reasonable expectation of privacy. So Justice Cote's characterization of the subject matter of the search is actually closely tethered to that position. So for her, based on the facts of the case, the subject matter of the search was, IP addresses. So the collection of numbers and the identity of the internet service provider that's revealed by them, and no more, she says. Now, she concedes that the police were not seeking IP addresses for their own sake in Bykovets, but for the information that they reveal. But she still insists that IP addresses on their own, reveal only limited information, so no biographical core of personal information which individuals should care to have protected. So on its own, an IP address does not even reveal browsing habits, right? So what the IP address reveals, she says, is a user's ISP, hardly more private information than, say, the heat emissions in Tesla, she says. Now, of course, the police were seeking to identify a person who used the IP addresses in the commission of the offenses, she says, but what they were doing so through a series of steps, and the step in question here reveal only the user's internet service provider. So from here, it's easy for her to conclude that Mr. Bykovets did not have an REP in the IP addresses associated with his internet uses. So the IP address didn't reveal anything that was private. He had little control over the IP addresses. And the place of the search, well, that was really the database owned by the company through which the transactions at stake were processed. Now, what about Karakatsanis in her majority opinion? The radical nature, I think, of her opinion is quite easy to see as compared to Justice Cote's opinion. Well, she just reiterates the mantra that Section 8 only applies when there's a reasonable expectation of privacy, but I think that opinion of hers hides a pretty deeply revisionist take on the application of that section. So she insists on a broad and functional approach to defining the subject matter of the search. She references Spencer, Maraca. She argues that the subject matter of a search has to be defined not only in terms of the information itself, but also in terms of the tendency of the information that is sought to support inferences in relation to other personal information. So the subject matter should be defined in terms, she says, of the potential of the information to reveal personal or biographical core information. And that entails that the subject matter of the search here, she says, is the information that IP addresses could reveal about specific internet users, including ultimately their identity, which is what the police were really after here. So she insists, she says, as the link that connects internet activity to a specific location, IP addresses may betray deeply personal information, including the identity of the device's user, without ever triggering a Spencer warrant requirement. Now, how so, you may ask? Well, because the state could, preemptively collect IP addresses and compare, a user's IP address against their database without, ever involving an ISP. And then she says the scope of information that an IP address can reveal is just enormous if it's correlated against information that's held by a third party, such as, Google or Facebook. And she says cases suggest that third parties actually provide this information to the police without even being asked. Now, in her dissent, Cote is quick to point out that in the case in Bykovets, the police didn't compare the IP addresses that they retrieved with proprietary databases, and you didn't have any third party that was consulted or that provided information. Now, that doesn't deter Justice Karakatsanis. According to her, she says an IP address, even if only seemingly revealing of seemingly innocuous information on its own, is the first digital breadcrumb or the key to so much personal information, including identifying information that's scattered around the internet and amongst, the third-party companies that aggregate information from it, that this fact cannot, be ignored when assessing the subject matter of the search. So from there, it's pretty easy for Karakatsanis to establish that there is an REP in the subject matter of the search. She says, look, IP addresses can lead to all sorts of things. Presumably, she's worried about people knowing about, what restaurants you go to, what her hobbies are, or, what dating services she may be using, or, what porn, right? So basically, she says, there's too much at stake here. And in the end, she says, just a warrant. It's just a warrant. If there's an REP, the presumption is that the police should have a warrant, and that burden is not onerous, she says. Now, what's left of the REP threshold after Bykovets? What I'll say here is in the US, there has been a theory of privacy called the mosaic theory of privacy that has been developed over time, which goes as follows. It basically requires court to apply the Fourth Amendment search doctrine to government conduct as a collective whole rather than in terms of isolated steps. Right. So one interpretation of Karakatsanis' opinion seems to be adopting this theory of privacy without identifying it by name. But I just want to note here that the mosaic theory of privacy was developed in relation to cases where the police were aggregating or were engaged in multi-step searches over time. In Bykovets, that wasn't the case. Right? The police was just focused on a singular, time-specific piece of information, namely 2 IP addresses. So they focus on a breadcrumb. Now, it's a key breadcrumb, which may be connected to other breadcrumbs, but the search in the case is not aggregative, right? And Cote goes to great length to pointing that. So what Karakatsanis may be arguing for is a kind of potential mosaic theory of privacy. Now, one might try to cabin this interpretation of her position by pointing out that, IP addresses are the first digital breadcrumb in the sense that they, are breadcrumb to people's activities on the internet, which are, qualitatively and quantitatively, markedly different, right? But note, she also recognizes that computers are different, right? And they, even when they're not connected to the internet, they can reveal a lot of personal information. So should we revisit McGregor based on that position? Remember that the court has also held that there's no place on earth where persons can have a greater expectation of privacy than within their dwelling house. So what about heat emanations as a breadcrumbs to what's going on in the house, or electricity usage, for example? Should we revisit Tesling or Plant or Gombach based on this? She does explicitly analogize an IP address to a street address in the judgment. I think that's telling. So if this interpretation of her opinion is sound, at which point does this reductio stop? Should, a reasonable expectation of privacy extend to any information that, may lead to other information in which one can more traditionally be said to have an RAP? A car license plate, a piece of clothing that may be connected to one's identity, abandoned DNA. Remember, the mosaic theory was developed in the US with respect to aggregating sort of data with respect to, for example, GPS tracking of cars. It didn't have to do with anything digital, right? Now, just to conclude, another perhaps more effective way of seeking to cabin Karakatsanis' opinion might be to insist on the passages in her opinion where she emphasizes that access to IP addresses is problematic because they're not just breadcrumbs, but they're the key breadcrumb, right, to unlocking someone's internet use. But you still have a question that remains as to what other breadcrumbs may be characterized as keys to important information, right? That's kind of the logic of investigations, right? That's how investigations proceed. You look for keys that lead to identifying information in the end. So it seems fair to ask, I think, what, if any, threshold to the applicability of Section 8 remains on the basis of the reasoning in Bykovets. And I think one can expect the issue to go back to the Supreme Court before long. There's a lot of other interesting things in the judgment. I point out some in the papers that I submitted with respect to the remedy, what that means for how we should interpret the application of the charter. So Bykovets, I think, is a very important decision, probably the most important in the last 10 years in Section 8. And I look forward to hearing what my colleagues have to say about this. Thank you.
So before I begin, I'm supposed to tell you that nothing I say should be reflective of the views of my employer, the Public Prosecution Service of Canada. They are my views alone. I'll start with just a little bit of background, which might seem a bit basic, but hopefully you'll see where I'm going. In Bykovets, the majority of the Supreme Court of Canada was really interested in informational privacy. And as I'm sure you're aware, the courts have identified 3 types of informational privacy. The first being privacy as secrecy. That's the ability to keep in confidence information that an individual wishes to keep private. So for instance, patients expect their doctors to keep their medical records private. Privacy as control, and that's the ability to decide when, how, and to what extent information about oneself will be shared. And then privacy as anonymity, and that's the ability to communicate publicly while remaining anonymous. So the contents of the communication are available, they're open, they're transparent, but the person doing the communicating, their identity is private. And the example that the courts use for privacy as anonymity, interestingly enough, are things like anonymous surveys, but also confidential informants. And this is important in my view, because Bykovitz is especially concerned with privacy as anonymity in online activity. And to understand where this could be headed, consider how jealously courts protect confidential informant information. So I'm sure many of you have had the experience of making a disclosure request in the context of a Section 8 application or carefully, and you hear the Crown respond, Your Honor, the information requested could tend to narrow the pool of potential confidential informants, and then your disclosure order is basically dismissed. And in essence, what the courts are recognize there is, you heard François refer to the mosaic theory. It's really the same with respect to confidential informants. The courts recognize a mosaic effect when it comes to confidential informant information. Nobody knows whether some innocuous detail can be combined with another innocuous detail to give away an informant's identity. Now with Bykovitz, some of you may want to turn the tables on some of us Crowns with this. You may say that the majority of the Supreme Court is applying a similar mosaic theory to protect anonymity in online data. And you may quote from the Supreme Court at paragraph 53 of Bykovitz, where the court says, because the analysis seeks to determine whether people generally have a privacy interest in the subject matter of the state search, we consider not only the information that police seek to uncover in a particular case, but all the information that the subject matter may tend to uncover. Or you may quote paragraph 60, that the court is not concerned, and argue that the court is not concerned with the information contained in the IP address itself. That is simply a series of numbers and digits, but rather what the court seeks to protect is activity associated with that IP address that could be correlated with other online activity associated with that address available to the state. Or you may quote paragraph 13 and submit that courts must safeguard the first digital breadcrumb and shroud the trail of an internet user's entire journey through cyberspace. But not so fast. I think Crowns may try to take a narrower interpretation. They may try to argue that Bykovitz is limited to its facts, where police actively sought out data held privately by a third-party company. And I'm going to try to walk you through what I think Crowns may try to argue in order to limit the scope of Bykovitz.
Unsuccessfully.
Specifically, Crowns might argue that not all digital breadcrumbs are in fact private. So if every digital breadcrumb is private, then no data is public. And I think Crowns will say this can't be the case. The courts have been clear that some data is in fact public, outward-facing, and doesn't touch on a person's core biographical details or their lifestyle choices, which is really what courts are trying to protect in this analysis. And so in the Ontario Court of Appeal, in a recent decision called El Azraq, which predates Bykovitz, court held that there are simply, quote, no intimate details concerning one's life revealed from just a home address. And they say, standing on its own, a cellular phone number does not engage with the lifestyle and personal choices of the accused. Similarly, in Telfer, the Manitoba Court of Appeal held that the accused name, credit card number, and phone number were simply mundane, basic information provided in the context of a regulated and commercial activity, namely car rentals. And the Alberta Court of Appeal, in a recent decision called Newman, held that the accused name and cell phone numbers, without more, did not constitute core biographical details which revealed intimate and private information or intimate details of the accused lifestyle and personal choices, infringing his dignity, integrity, and anonymity. Now, Crowns might also say not all IP addresses deserve protection. Sometimes IP addresses are a critical and inherent part of public activity. For instance, users can't participate in peer-to-peer file sharing programs like LimeWire or BitTorrent without using their IP addresses as digital identifiers. And police obtain such IP addresses using publicly available software. And there's no single repository of IP addresses against which police can obtain a court order. In other words, they can't say to a judge or a justice, hey, you need to order this person over here or this organization over there to give me the IP address. Such a organization just doesn't exist. For an interesting commentary on this, you may want to have a look at a decision called Curry, which is a decision of Justice Silverman in the British Columbia Provincial Court. It's in my, referred to in my materials, where Justice Curry essentially found that an IP address was protected, or a reasonable expectation of privacy did cover an IP address in a peer-to-peer file sharing network pursuant to Bytkovits, but he specifically identified this kind of tension. But more than that, Section 49, subparagraph 2 of the Criminal Code permits the police to seize without a warrant things that are found where the officer is lawfully present in the execution of his or her duties, and where the officer believes on reasonable grounds that the thing will afford evidence of an offense. And so if the officer is using publicly available software to find publicly available information about an IP address, then arguably, and I say arguably, those officers had seized it pursuant to this provision. Crowns might also try to argue that no prior judicial authorization is required for passively acquired data and voluntary reports on criminal activity. The holding in Bytkovits may be restricted to circumstances where the police actively seek out data held by third parties. But the question is, what if it is provided to them? And the Ontario Court of Appeal has held that this is a seizure, although I note that they've also pointed out that the Supreme Court hasn't decided that definitively, so maybe a question. But the Ontario Court of Appeal has held that it's a seizure. But such a seizure might be authorized under Section 49, sub 2 of the Criminal Code in some circumstances. There's a recent decision called Lambert of the Ontario Court of Appeal, where the accused wife discovered child pornography on his computer and turned it over to the police on her own volition. And the court held that the officer was authorized to seize the computer because he believed that it would afford evidence of an offense. And this was enough to permit the Crown to rely on Section 49, sub 2, notwithstanding the fact that the police officer didn't believe that he was required to invoke that provision. In fact, simply the fact that he thought that it was that it would provide evidence of an offense was sufficient for a warrantless seizure. Crowns might also argue that not all online activity gives rise to a reasonable expectation of privacy. There's a difference between an Instagram account used by a teenager to share photos with her friends and between an Instagram account used by Taylor Swift to reach her audience. And some Crowns might try to argue that your client's account is a lot more like Taylor Swift's than that anonymous teenager. In McPherson, Justice Code held that there is simply no monolithic Section 8 doctrine or rule relating to social media and online spaces, unlike the home or the personal computer, where broad Section 8 generalizations have emerged from the case law. McPherson involved undercover officers monitoring Instagram accounts. And in the circumstances, Justice Code found that there was no reasonable expectation of privacy, in part because many of the accounts were public. The account holders accepted the undercover officers' follow requests without taking steps to protect their privacy. The accounts had a large number of followers. And in particular, the accounts were held by members, or alleged members of the Eglinton West Crips. And Justice Code found that the accounts were intended to advertise and assert the existence of that group. And so, in other words, online spaces are context dependent. And I'd also like to talk about cryptocurrency transactions and whether they give rise to a reasonable expectation of privacy. Cryptocurrency transactions are not necessarily private. I don't know of a Canadian court that has actually dealt with the issue, but the Fifth Circuit Court of Appeal in the United States came to a decision called United States and Gretkowski, where they held that there was no reasonable expectation of privacy in the Bitcoin blockchain. In that case, American authorities used an outside software to identify a cluster of Bitcoin addresses associated with a child pornography website from which the accused had downloaded material. The court held that the blockchain only records limited information. That is, the amount of Bitcoin transferred, the Bitcoin address of the sending party, and the Bitcoin address of the receiving party. And further, transacting through Bitcoin is not a pervasive, this is their quote, a pervasive or insistent part of daily life. And they say transferring Bitcoin requires an affirmative act by the Bitcoin address holder. In other words, people don't use Bitcoin for routine purchases. It doesn't tell you much about their life. Courts don't have much to worry about. That's what the Fifth Circuit Court, I think, in essence, was saying. It's also worth noting that Bitcoin has inherent features that make it possible to identify users through something called clustering, unless those users take their own self-help methods. And for information about that, have a look at the white paper authored by the founder of Bitcoin, Satoshi Nakamoto. And then lastly, not all third-party data comes from entities that are subject to the charter. The majority in Bykovitz seems concerned about the state use of data in the hands of private companies. However, many of these companies are in the United States, and the Supreme Court has been pretty clear in a case called HAPE that information provided by foreign authorities through mutual legal assistance is worthy of comity, and as such, is not subject to charter scrutiny, absent, of course, clear violations of human rights or the charter principles. Now, this might protect some information. And in addition to that, the weight of authority in Canada is that Canadian courts have jurisdiction to compel data from companies that have a real and substantial connection to Canada, including a virtual presence. But some of these companies have been known to resist production orders and warrants and the like on the basis of conflicts of law arguments. For instance, Google did this in a 2020 case called Strong, Justice DeLuca up in Newmarket. And as a result, law enforcement may need to rely on mutual legal assistance, bringing the production of documents outside the scope of charter scrutiny. So in sum, the question going forward is whether Bykovitz is a narrow decision that protects only IP addresses that the police actively seek to obtain from third-party companies, or does it establish a reasonable expectation of privacy over every digital breadcrumb on the trail of a user's online activity? We'll see.
So unlike the professor sitting to my right, I'm the defense lawyer on this panel. So that means I'm the least prepared this morning, which means over the next 10 minutes I do have, I'll find out what I'm going to say about this riveting topic of IP addresses at 8:30 in the morning. I think I'm up here because I was one of the interveners on Bykovitz, and the decision as it came out was a little surprising, not because I agree with my friends up here that Bykovitz was a sea change, but because of how it came about. When we argued it in January of last year, I believe it might have been Justice Brown's last hearing, and he was not, at least in the oral hearing, really receptive to the arguments that an IP address should attract a reasonable expectation of privacy. And I'm not going to speak for Justice Brown in terms of how he might have voted. But we waited until about September, which is quite a long so the lead time is about 5 to 6 months from an oral hearing for the SEC to release a decision. We received correspondence saying that the court was going to do a rehearing. I'd never heard of that before, and they did a rehearing by watching the video. And that, of course, made me nervous because I had to go watch myself to see if what I thought I said actually came out of my mouth, and clearly it didn't, as all of you know. It happens often. And it's an exhibit A in the type of advocacy that you don't want to do at the Supreme Court of Canada. But upon getting the rehearing, they said that they were going to give us questions in writing. None of those came, and we received a decision of January of this year with a 5-4 decision with Justice Morrow, Justice Brown's replacement, with the majority. So the decision was clearly split. It was one, I think, that as François has set out very clearly, creates sort of a divide in terms of how one might apply the normative approach to varying areas. I don't say that Bykovitz is a sea change. I say that Bykovitz is an example of the law and Section 8 catching up to technological advancements, catching up to our digital age. And while Bykovitz might seem unusual because it really focused in on sort of the IP address itself, what drove the analysis in Bykovitz was the idea that these internet companies had a concentration of our data. They would collate it, they would use it, they would distribute it, and often without our knowledge, often without our consent, or at least not informed consent. I don't know if any of you actually read the privacy pop-ups and you just click OK so you can look at your Instagram, right? I don't know. I don't know if that's how Instagram works. I don't have it. But it really was about the way in which these companies would aggregate this data and how an IP address really unlocks it. So while Justice Karakatsanis uses the metaphor that was used in Spencer of the breadcrumb and says that it's the first breadcrumb, she's really saying, in my view, is it's the most important breadcrumb. You don't get to a protection of privacy unless you have that IP address connected to other information. Your password in your phone is probably meaningless unless it's your birth date or something else, anniversary date. But it has meaning when you punch it into the phone because all of a sudden you have access to all that data. So I do think that Bykovitz has to be read that way. None of the defense lawyers here should be going into court saying that Bykovitz stands for the proposition that an IP address in all circumstances will attract a reasonable expectation of privacy, and that it's fair game to just say any breadcrumb also would attract that privacy interest. I think you have to be careful and nuanced in the way you approach those arguments. We're not alone, by the way. I mean, it's not like Canada is an anomaly. Justice Karakatsanis did note that in the UK, they consider under their it's the Data Protection Act. They say that the browser-generated information is personal data. The EU has confirmed that they protect IP addresses because they are concerned with the indirect information that it may reveal. And that's why the normative approach asks not what in a slice of time something reveals, but what it tends to reveal in the aggregate. So it makes for, I think François said, a woolly test when you talk about the normative approach, but as defense lawyers, that's great. I mean, it gives us an opportunity to really sort of push the law sometimes and really have the ability to try to make some creative arguments. One of the, and I see that I have only 5 minutes, which is giving me some PTSD because Chief Justice Wagner is an iron fist when it comes to the 5 minutes you have as an intervener. But Ira did go over some of the open questions that might arise from Bykovitz, and one of the questions that I hear repeatedly is, what if a third party with that private data goes voluntarily to the police and provides it to them? Do the police need to get a warrant? Lambert seems to suggest, at least through Justice Pacheco, that was settled in the Cole decision when the Supreme Court of Canada decided that a teacher's laptop can't just be given to the police just because the school has control and access to that same laptop. I would urge everyone in this room who's a defense lawyer to continue to make that argument. And it may be, though, that because Justice Karakatsanis in Reeves seemed to suggest that that question is still open, that it may have to be resolved up there. But at least in Ontario, it seems to be that There's some jurisprudence that should help you establish that. And I don't know, did you refer to the Nelson decision?
I did. I just didn't name it.
Yeah, the Nelson decision, KNELSEN, out of this year from the Ontario Court of Appeal. There's a footnote there. So, Ira's very studious. He looks at the footnotes of the judge's decisions. You don't want to do that with Justice Wakeling out of the Alberta Court of Appeal. You'll be doing that for days. But the footnote number 6, Justice Van Rensburg seems to suggest that it's still an open question, despite what Justice Pichalko said in Lambert. So, and I can tell you that the BC courts have been against the idea that the police would need a warrant to obtain information that's being voluntarily given by a third party. But I would say that the reasoning in Cole is sound. I mean, if you can't give up your privacy rights because someone you're sharing the sort of sphere of privacy with decides to consent to give it to the police, I'm not sure why a third party should be able to, a third-party company, for example, on the internet, just be able to approach the police and give them information. And this does happen, of course, in the child porn context, where here we have I think in the States there's the child exploitation national, I'm getting it all wrong. But there's the entity in the States that passively receives information, including IP addresses, that might be connected to child pornography, and then contacting the police. We have that here with the RCMP as well. I'd suggest that if the police want to, the police can certainly obtain that information. It can certainly form grounds as hearsay for an application for a warrant, and a warrant that, by the way, Justice Karakatsanis had noted, would be available on the reasonable suspicion standard. But I don't see that the privacy interest would be extinguished just because it's in the hands of a third party. We and the Supreme Court of Canada rejected the third-party control doctrine from the United States, where in the United States, if a third party has your private information, you have effectively waived your privacy interests. But we've already rejected that in Cole. It was rejected in Morocco. So I do think that the winds are on our backs to be able to say that even if a third party has that information, the police can't seize and use that information until they first get judicial authorization. And so I've about 30 seconds left. I would just say that the other thing I'd ask you to think about is whether the reasonable expectation of privacy analysis should take into account law enforcement interests. Now, if you look through the jurisprudence at the Supreme Court of Canada, it often comes up more recently in concurring or minority judgments. Justice Karakatsanis in Bykovitz asked that question, and I was tongue-tied because I intended to talk about it in our intervener materials, but I was too preoccupied with skip the dishes, knowing that I didn't know how to cook. And so I didn't get that out. And so I don't think that it should play a role, if any, or even a small role, because there are other stages in the Section 8 framework where law enforcement interests are taken into account, like the ancillary powers doctrine, like the reasonableness of a law under Section 1. So I do ask that you think about how law enforcement interests might have any relevance on the expectation of privacy analysis at the outset. Thanks.
Got my hands full here, but please join me in thanking our panel once again.